Good morning to members of the media and the listening public. Today, I am joined with Ms. Marita Grimes, the Assistant Chief Immigration Officer, Ms. Nakia Skraders, the Acting Immigration Manager, and Ms. Kelly Parent-Chief Burgess, the Compliance Manager in the Department of Immigration. I would like to announce that the Department of Immigration will be adopting a zero-tolerance policy against those who disregard our immigration laws and policies. As we navigate the intricacies of immigration laws and employment regulations, employers and work permit holders must understand and follow the established laws and policies. Today, I will address critical issues related to late work permit applications, civil penalties, and visitor stays. We will also provide essential clarification to help all stakeholders ensure compliance and avoid any legal repercussions. Let's begin with late work permit applications. The Department of Immigration has seen an increase in the number of late work permit applications, specifically for individuals already residing in Bermuda. In many instances, work permit holders have continued to work after their permit has expired without the approval of the minister. To address this, I want to remind employers, immigration agencies, and work permit holders of Section 4 and 4.1 of the 2017 Work Permit Policy. These sections instruct that renewal work permits should be submitted no less than 1 month and no more than 3 months before the current permit expires. If applications are submitted outside this timeline, that is, with less than 1 month to go before the permit ends, the work permit holder must immediately stop working when their current work permit expires. Too often, stakeholders wait for the department to issue a stop work order. This is unnecessary. The policy is clear and must be followed. Additionally, late applications will incur monthly late fees. The department has adopted a zero-tolerance policy for late submissions and appeals. To continue working in such cases, they will be refused. However, when an application is submitted within the 1 to 3 month window, the has to continue work after it expires while the department processes the renewal. I must also remind employers, immigration agencies, and work permit holders of Section 71A of the Bermuda Immigration and Protection Act 1956, which empowers the Chief Immigration Officer to issue civil penalties where a work permit holder has worked without a valid work permit or worked outside the scope of their work permit. Employers and work permit holders will be fined per individual, not as a group, and the penalties are as follows: $5,000 per party for a first instance, $10,000 per party for any subsequent offense within a 7-year period. To be clear, employers with multiple offending work permit holders will be fined either $5,000 or $10,000 per individual. Employers are ultimately responsible for compliance with both the policy and the act. It is critical to select immigration agencies who uphold these standards. However, failure to comply cannot be blamed on the agency. Liability rests with the employer. With that said, I urge immigration agencies to operate responsibly and to a standard that protects not only the integrity of their business, but also the interests of employers and work permit holders. Work permit holders are also encouraged to take greater responsibility for understanding their obligation underneath the policy and the act. Individuals without a valid work permit must not work and should seek immediate guidance by contacting the Department of Immigration at 246-8093. Work permit holders found working without approval may be barred from future employment in Bermuda. Employers are strongly urged to verify the work permit status of their employees to avoid severe consequences. In addition, beyond violations against the Act, work permit holders who are terminated for misconduct will be directed to settle their affairs and leave Bermuda, and must remain off island for at least 2 years. Visitors are reminded that they must stay in Bermuda for up to 180 days within any 12-month period. While in Bermuda, they are restricted from working or seeking employment. Violations will result in restriction of future entry. Note that visual arrivals and departure information is now tracked by the new border management system. Individuals who overstay are automatically flagged and referred to the immigration compliance section. At this time, I want to remind everyone of the 3 ways to report an immigration violation. The public may call the anonymous tip line at 296-5202. Visit the Department of Immigration to speak with an compliance inspector, or send a letter addressed to the Department of Immigration, 1st floor, Government Administration Building, 30 Parliament Street, Hamilton, outlining the details of the breach. In closing, adherence to the 2017 Work Permit Policy and the Bermuda Immigration and Protection Act 1956 is crucial to preserving the integrity of Bermuda's immigration system. I call on all employers, immigration agencies, and work permit holders to work in partnership with the Department of Immigration to ensure compliance. Together, we can foster a fair, efficient, and well-regulated system that supports economic growth and continued success of our community. Finally, I am excited to announce that a revised 2025 work permit policy will be released in the coming weeks. Public feedback will be welcome to ensure the new policy meets the needs of all stakeholders and reflects our commitment to the continuous improvement of our immigration system. Thank you.
Thank you, Minister, for your briefing. We'll invite media questions right now, beginning with the Royal Gazette.
Minister, good afternoon. Gareth Finnegan, Royal Gazette. You started by saying that you're now going to adopt a zero tolerance policy. Is that something that you haven't been doing? And if not, why not?
So at times you have exceptions, and we found that the exception is becoming the norm. And so we had a point in time where employers were submitting their work permits on time. Now we find an increased level of appeals. Appeals were the exception in the past. Appeals are becoming the norm. And so what we want to do is inform employers and immigration agencies that we will no longer be approving appeals or entertaining appeals to force persons to the standards which are set within the work permit policy.
Sure. But just how widespread is it? How widespread a problem is it? Do you have any numbers as to how many work permits there are, and then how many of those are sort of being filed late or some other breach?
Well, we put out the number of work permits processed annually, publicly. That is not the challenge. The challenge is the additional work that the team has to do to, number one, handle appeals and then process work permits. But we should not be entertaining appeals when the policy is set out clear as to what is the expectations. And so what we want employers to do is adhere to the policy. I would say that the number of appeals that have come in is one too many.
Okay. And could you say, sorry, I've lost my train of thought. These new penalties, these penalties of 5,000 and 10,000, are they new, or have they, they've always been in existence, but?
These are existing penalties, and we have been fining individuals over the years. I just want to remind employers that there are fines for breaches to our laws and policies. Many times they use employment agencies, and they're not being advised. And what happens is, under law, it's the employer's responsibility, but they rely on these immigration agencies to provide them with advice. And sometimes the advice that they're receiving is not accurate, and also puts them in breach of the law. and then they are subject to the fines and the civil penalties.
How long is it taking for work permits to be processed on average? Because isn't it sometimes the case of you can submit a work application within the 1 to 3 month time frame, but it might take several months for that application to be approved. Is it sort of a case of a company will have to ask immigration if once the work permit expires and they say we've submitted this work permit and we've complied with all the regulations, can this staff member carry on working?
So that is what I articulated, that as long as the work permit has been submitted in a timely manner, that what we will do is we will allow for persons to continue to work while the permit has actually been approved. What we find is that persons are waiting till the work permit expires. They don't submit a renewal until days after the permit expires, sometimes months after the permit expires. But what we're finding is persons are continuing to work during that period of time. The policy makes it clear that once you do not have an active work permit, you have to stop work unless you've received permission from the minister.
But can you, if you have to stop work, can they still stay on the island?
Most definitely.
Yeah. Although that would be difficult if they can't work, for example. Don't you think that's going to cause problems?
No, you have rules in place, and the rules are that you have ample time to submit a renewal permit. And what we're asking persons to do is not wait till their employees' work permits expire to begin the process of submitting a renewal.
Okay.
Submit the renewal at least between the window of 1 and 3 months prior to the expiration date. If the permit is in, you can then appeal to the minister, and we can allow the person to continue to work while the permit is being processed. What we're finding is in some cases, a work permit has expired. Sometimes people go on working for 6 months with no approval from the minister, and then we see renewal applications coming in. That is unacceptable. In those cases, persons will then be fined. And I'm making it abundantly clear that we will not be accepting those sorts of applications moving forward, and we will not be entertaining appeals for submissions that come in late.
And finally, you talked about some new regulations coming in, and you're going to try and get feedback from stakeholders. Could you provide any details on any of those new policies, and why do you think they're needed?
So I will do a full press release in terms of a press conference for the 2020 rollout of the 2025 work permit policy. That policy would be based off of work that we've done in conjunction with the Department of Immigration and the Immigration Board. We're going to put it forward so that employers can opine on some of the changes we're making. But some high-level changes would be around layoffs, ensuring that if you have a Bermudian and a non-Bermudian in a like position, that when it comes to layoffs, that the Bermudian is retained and the work permit holder is laid off as first and foremost. It has to do around English proficiency. In our current act, we say that persons working in Bermuda must have English proficiency. What we're finding is persons are not adhering to that particular standard, and what we will do is ensure that in alignment with submission of a work permit, that they have some type of proof of English proficiency in the form of a test. We're also going to streamline the wording so that it's clear and less ambiguous in a number of areas. But you will see that it is an enhancement of the 2017 policy.
Okay. Minister, thank you so much.
Thank you.
Thank you, Gareth. Bermuda Broadcasting.
Good morning, Minister.
Good morning.
And members of the Department of Immigration. Gary Foster-Skelton, Bermuda Broadcasting. We have members of the Department of Immigration here, so you might be able to give us a bit more of a picture of what's happening here. You said that it's becoming, the exception is becoming the norm as such in that for late applications for work permits. Can you give us a trend? When did this start? Because out of all the work permits that are put out in a year, what percentage of those has been late applications, or people working who've continued working without a work permit? Can we get a trend over the last few years?
So what I do is I have weekly meetings with the immigration team, which comprises the ladies who I have next to me, as well as the permanent secretary and chief immigration officer. And I would say a large volume of the meeting time is taken up handling appeals. And so what we don't want to do is remain in a space where these appeals are actually the norm. Because I always ask the team, what does the policy say? What does the law say? And why are employers not adhering to the law? What we're finding is that most times it's not the employer's fault, it's employment agencies, immigration agencies' fault, where they have multiple contracts with various employers. And so if they try it with one application, you can see where they can then do it for multiple applications because they deal with multiple clients. And so they say, okay, I tried this before up immigration event work, and this becomes the norm in terms of the modus operandi with their clients. What we want to see is a strict adherence to the policies that we have set out in the work permit policy.
So is it reasonable to say that you're standing here, you're not only talking to your to the employment agencies and the employees out there, you're also speaking to the Department of Immigration itself. You're saying, I don't want to be sitting in these meetings talking about appeals. Can we get past this? Is this what you're saying to your ministry and your department right now?
I think the team is collectively dissatisfied with the manner in which permits are being submitted. And so this is the team's appeal to employers, employees, and agencies to ensure that they adhere to the immigration policy.
Is this a bit of a knock-on from the pandemic? Was there, in some ways, some leniency given during that period, and has it kind of carried on? Can we look back at it in that way?
I think that you can see trends in terms of visitor stays. When I talked about persons staying over the 180-day period, during the pandemic, we had travel restrictions, and as a result of that, persons were staying longer than they were due to stay. A lot of it was within reason, based off of the inability to travel during the pandemic. And so that may have been a knock-on effect, and that's why we're informing visitors that we changed the law. We've moved visitor stays from 90 days to 180 days. And so we've given you an additional 90 days to remain on island, and persons are still exceeding that 180-day period. We're saying that moving forward, we will absolutely not be tolerating overstays.
Okay. And are you able to give us a little more insight? Is this affecting certain industries, or is it across the board that you're facing these problems?
Across the board in all industrial categories.
Okay. And finally, just on those, going back to those penalty fees, are you able to give us a little detail of how many times employers have had to pay those fees over these past few years? And is it a case that you're going to be putting those fines in place a lot more going forward?
When we do the budget brief, I'll ensure that I provide the statistics in terms of the compliance penalties and the amount of money received by the immigration via compliance penalties.
Okay. And finally, just that question of visitors coming who don't have a work permit and working while here as visitors. How is that something that has increased? Again, you just kind of hinted at it, the post-pandemic period. Is that a problem that has continued to increase?
We do receive complaints regarding visitors who may have arrived and commenced work in Bermuda or even sought employment in Bermuda. Where we receive those complaints, we inform the compliance team, and the compliance team investigate those complaints immediately. I wouldn't say that that is the norm as it pertains to visitors, but there is some abuse, and wherever we find abuse, there will be penalties.
I do want to go back to one thing that you, quoting you, saying sometimes people have continued working without a work permit for 6 months. How, with the Department of Immigration standing next to you, how is anyone getting away with that?
Right now, with our revised border management system, we can now battle track those occurrences. But, for example, if an employee's work permit expires, it's the employer's responsibility to ensure that they either repatriate that employee or they get a work permit renewal. There is a 90-day period of time where an employee is allowed to remain on island to settle affairs. And so if you've worked in Bermuda for 3 years, at the end of the expiration of your work permit, you can have an additional 90 days to remain on island to settle your affairs. What we find is that if that work permit expires, we don't know if persons are actually selling the affairs or in the process of submitting a new work permit. And so that 90-day window is somewhat of a gray area. Okay. But our compliance team will certainly work to ensure that we reduce the occurrences of persons working outside of, work permits. We're asking the public to help us out. We do receive complaints on an ongoing basis, and we want to continue to encourage the public to submit complaints. But the behavior must stop, and the behavior must change as it pertains to compliance with our immigration rules and laws.
Okay. Thank you, Minister. Thank you, Department.
Thank you again, Minister, for your briefing. And if there are no further remarks, that concludes today's presentation.
Thank you.